All right, we are present in two cases, 24 CR 432 and 24 CR 015. Both of these are captioned State of Ohio versus Cortez Hopper, and which one's which? 4015 is City Bonding and Universal Fire and Insurance Company, and 432 is Universal Fire, and is it Turcosi? I don't know if I pronounced that right. How do you pronounce it? Turcosi. Okay. In this case, two separate bonds were posted, one by each of the separate bonding companies. The defendant failed to appear for his hearings in this matter. First the change of plea hearing, then the trial. That was back in July of 2024. Bond was forfeited, a hearing was scheduled. Court continued at one time to give the bonding company an opportunity to bring in the defendant. They didn't do that. Second hearing was set at the request of the bonding companies, and nobody showed up for that. So bond was forfeited. The defendant was ultimately arrested. The defense bonding company's sureties have now filed a motion to vacate the bond judgment and relieve them of liability. We're here for a hearing on that. Mr. Kuharski, you recently, I'm assuming, filed a notice of an appearance on.
Yes, Your Honor. Yes, Your Honor.
So Timothy Kuharski is here on behalf of the two bonding companies, two sureties. Mr. Nicholas Geigerich is here on behalf of the state of Ohio. So Mr. Kuharski, your motion, I'll let you present what you want me to consider.
Your Honor, there's two things. I think that as far as how the judgment came on, the bonding company and the initial attorney for the bonding company didn't receive notice. I have an affidavit from...
Didn't receive notice of what?
Of the hearing date. The second one, Your Honor.
Then you know what? I will never continue them again. Cause that's, go ahead.
Your Honor, I'm only basing on what the evidence I've been given. I don't know anything else.
They just thought it disappeared and went away?
No, I don't think they
sounds like one of the defendants that we deal with.
I don't think they thought that it disappeared. They just didn't know the specific date that it was. But Your Honor, beyond that, this case involves Mr. Hopper, who didn't show up. Immediately upon receiving your notice that, in fact, the bond was forfeited, the bonding company utilized the procedures that they use for other individuals who don't show up for court. They hired a bounty hunter, that's Mr. Nunn here, who's in court today, and then him and his team, along with City Bonding and Universal Bonding, create a plan as to how to find the individual. I can call Mr. Nunn to testify. He's prepared an affidavit as to all the efforts that he did. This is not a situation where City Bonding and Universal Bonding were just sitting back and just saying, geez, let's hope he shows up. They were actively involved in everything. They were actively involved contacting Steubenville police. They actually, and
I want to know what, if any, involvement they had in his actual arrest. Because if they had nothing to do with it, I don't care what efforts were made. I mean, otherwise, a bonding surety is the best job in the entire world because there's no risk. All they got to do is wait for a person to get arrested. It could be a year later, a month later, 5 years later, and then file a motion saying, oh, he's back in custody. We didn't have anything to do with it, but he's in custody, so relieve the judgment.
They actually, the bonding company had filed a number of leads as to where the individual was, Mr. Hopper was. They then went down to, they found out that he was supposed to be in Steubenville. My understanding is that they may have contacted the Steubenville Police Department saying that, look, we're looking for this. We may be executing, to obtain him on a forfeiture. Ultimately, Steubenville became aware that Mr. Hopper was down in their vicinity. They then arrested Mr. Hopper. But more importantly, Your Honor, this is where I think that the issue comes down to. When Steubenville took Mr. Hopper into custody, there was no hold from this particular court. And so it was Mr. Nunn who contacted Steubenville to say no, because that's why Steubenville contacted, and that's how the information became noticed. Mr. Nunn, there's a program called Watchdog that notifies when anyone is taken into custody. It was notified Mr. Nunn that, in fact, Mr. Hopper was taken into custody in Steubenville.
What was he taken into custody for?
apparently a new charge that's never been filed, Your Honor. And so we're not really sure. There's nothing that's there. I'm not aware of any new charge. I don't know if it's there's nothing on the docket that would indicate that Mr. Hopper has a new case down in Steubenville, Ohio. But as I said, more importantly, what happened is after that, Steubenville checked the wants and warrants. They determined there was no hold on him.
What do you mean no hold? No warrant that was its issue?
Correct. There was nothing in their system that would indicate it. Mr. Nunn then contacted Steubenville and said, no, I have a warrant from Lake County, and he made sure that the Steubenville Police Department received all that notification. Mr. Nunn then said, hold him, can you hold him until I get him? I will come down and get him. At which point then, through a number of conversations, the Lake County matter came down, they recognized that there was a hold, and they said, okay, yes.
You're using the word hold. What do you mean hold?
That they weren't.
I know the holder is, but that doesn't seem like there was a warrant for him versus a hold. A hold is when the county that has the warrant knows that he's somewhere, and they'll contact that authority and say, we have a warrant for him, so we're going to put a holder on him, so whenever you release him, make sure you call us. That's
Right.
A holder.
Right, there was no hold.
There wouldn't be a hold. They'd have to have noticed that there. But you're saying there was no warrant.
There was no warrant.
In the system.
In the system. I believe there was a warrant because you issued it, but I don't believe it got into the system for anyone
Because
else.
Lake County wouldn't have a holder on him because they would have to
Correct.
be notified that he was arrested. Then they would place
Correct.
a holder on him.
They were not aware of your warrant that was issued to do anything with Mr. Hopper. And so, but for the activities and the conduct of the bonding company and their bail bonds individuals, Steubenville would have released Mr. Hopper back into the public. And if that was the case, and then I think that the state would have an argument to say, yes, city bonding should, if they did nothing, then okay, then perhaps the forfeiture would be appropriate. But it was the acts and the conduct of city bonding and universal bonding.
Well, I guess I'm going to want to hear evidence on this.
Okay. I can call Mr. Nunn to the...
Do whatever you think you need to do.
Mr. Nunn?
Yes. Mr. You could stay there.
Oh.
I mean, this is very informal.
Okay.
Raise your right hand for me. Do you swear from the statement the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You just have a seat there. It's easier.
Mr. Nunn?
You all right with that? You can see him all right?
We've already established what your name is.
Can you just have him spell his last?
Oh,
spell it?
could you state and spell your name? Sorry.
It's Maury Nunn. It's Maurie. Last name Nunn, Nunn.
And how are you employed?
I do marketing and skip tracing for city bonding / Tarosi bonding.
Right. What is skip tracing or?
When someone skips bail, I receive the paperwork to locate the person, arrest them, and put them back in jail.
All right. Now, are you familiar with the case Cortez Hopper?
Yes, I am.
All right. And you remember when, I don't know if you know the specific dates, but they're the dates that we're here for, correct? The cases that we're here for today?
Yes.
All right. And do you remember when you received notification from someone at city bonding?
It was 7/16 of 2024.
All right. And who did you receive notice about? How do you get your, I would say, assignments?
Well, I get the notifications from Penny Johnson.
Okay.
Right here.
Seated to your left.
Yes.
All right. And she's in charge of city bonding and kind of universal bonding in the city of Cleveland?
Yes.
All right. And so you received notice. What happened when you received notice?
Well, usually with a case, I receive notice and I usually immediately look over the case and start skip tracing. I put it in what I call a queue with my other cases. But since this case had such a high bond on it, I put it at the front of my queue, and I took some of my other cases, which I had like 4 or 5 cases at the time, and I put them on the back end and put the focus on this case.
All right.
Because it was high priority.
All right. And so what did you do in order to, so what do you do to find the defendant who has skipped or not appeared at court?
Well, first, I look at the paperwork because I have to verify who everyone is on the application. I try to locate them, see where they're at. see how they're related to the defendant, and it's usually about 3 or 4 hours worth of computer work to start with right off the rip,
All right.
or longer.
And so do you look at the application, the bond application that the defendant has prepared?
Yes,
And are there co-signers on the bond application paperwork?
yes.
Right. And then do you contact those individuals who are the co-signers on the bond?
Well, usually Ms. Johnson contacts them beforehand. When I get the paperwork, I usually fill out the case and see if I should contact them or not. This particular case, after I looked over the paperwork, I didn't contact anyone to start with because I kind of got a feeling that this guy was going to run, and I wasn't pulling up valid addresses. The only person I really was able to pull up valid information on was the mom, his
Okay.
mother.
And that's Tanya Hopper?
Yes.
All right. And so then what happened if you get the impression, did you contact Ms. Hopper?
Actually, I waited about, I'm gonna say it was about 30 days because, actually a little more than 30 days probably, because I was trying to locate Mr. Hopper himself before
Okay.
going to her house.
And what efforts do you use to locate a defendant?
I use different search engines. I use, one of the main ones I use is IRB, which you can put a person's information in there and it'll give you a list of current addresses, prior addresses. And then I was more so interested in, not so more of his mom, because mostly the people on the app, the odds of a person with this type of bond being at one of their locations is slim to none. So I was looking for his affiliates and people he had caught prior cases with and stuff like that, which one of them was a brother of his.
Okay. And what did you do with, and this is a blood brother of his?
Yes.
Okay. And so what did you do? Did the brother also have a case with Mr. Hopper?
I don't think his case was with Mr. Hopper, but he had a probation violation.
Okay. And so were you able to contact the brother?
Well, that's the catch. I pulled up between Mr. Hopper and his brother. They had, I'm gonna say it was like 15 to 20 addresses that was coming back to them. And out of the 15 to 20 addresses, I'm gonna say at least half of those addresses were current, like showing his current addresses. So what I did at that point, I split my team up and we would sit and do surveillance on those multiple addresses. We would talk to the neighbors at those addresses and stuff like that.
All right. So you have other individuals working for you in order to apprehend the defendant who had skipped?
Yes, it's no way possible I could do that by myself.
So if I understand, you have about 15 addresses, 15 to 20 addresses, whatever it is. You have a team and then you sit, and that means you just sit outside, or you just monitor that residence to see if the
Correct.
defendant comes or goes, or who's coming and going from that residence?
Yeah, we try to do surveillance first, and then depending on the areas and stuff, we'll try to speak with like a neighbor. We'll look and see if it's a neighbor that we think we can trust, and we'll speak with the neighbor. And once we rule out the person is not at that address no more or had moved, we'll cross that address off. So we had to rule out the addresses.
All right, so is this something you can do in a day or 2 days, and you cross off all 15 to 20 addresses, or is this something that takes weeks to actually complete, to make sure you're to complete? Well, let me back up. Do you just sit in the house for 1 hour, and if you don't see the individual, you just go home and say that's not a good address, or you sit on it for a lengthy period of time?
No, I actually have to rule out the address like almost 100%.
All right, and how do you do that?
We sit and do a lot of surveillance. Sometimes we'll just, if it doesn't seem like the person we're looking for is there, we'll go knock on the address, or we'll talk to a neighbor, or we'll run a search on that address. And you can see sometimes when you run a search if it's new neighbors at that address. But a lot of these addresses was either people that was affiliated with them or relatives of theirs also.
All right, and so out of these 15 or 20 addresses, did any of them come back as, yes, Mr. Hopper is at any of those addresses?
We got an informant that came into our actual office, I'm gonna say like 5 months into the case. where we got our first break, and she said she actually knew them. She knew the brother by name, which no one knew who the brother was, but she knew the brother by name, and she knew one of the females that Hopper was known to be with by name. She gave us an address that they were supposedly living in, and it's called Georgetown Estates. We have a lot of cases over there, so I'm real familiar with the property managers and stuff over there. So I went over there and spoke with them, spoke to the maintenance guy who helped us with a lot of previous cases. He was familiar with, he hadn't seen Hopper, but he was familiar with the female, and when she moved into the address, it coincided with what the informant said. So we spent a lot of time watching that address and didn't see him at all either. And we was also told that he travels in and out of town a lot with his brothers and them to Florida, to New York, and stuff like that.
All right, and so were you trying to look to determine whether there was any activity in New York and Florida or other places in and around Ohio? And around the country, for that matter?
We were trying everything, but mainly we was also trying to locate the other two signers on the application, which was his baby mother was one of them, and her mother was the other signer. And we could not find them nowhere.
Okay, and so because you couldn't find them, does that mean that the investigation ends, or do you continue to redouble your efforts?
Well, with a lot of agents, it ends, but they call me picky a lot of times. I believe that no one can get away everyone can be found. So after, I still never found the mom, but I found his baby mother, because she had caught a case in Cuyahoga County, and that's when I found out that she was supposedly living in a homeless shelter, and his mom had her kids, well, their kids together. So that was kind of like the first break we actually got in the case.
All right, and then what did you do when you learned about that the children were at the grandmother's house, we'll say?
Well, this was like 6 months later or so. We went to the mom's house and actually started pressing her again. And I actually sat her down and had a long talk with her, and she started crying because I told her that she was going to be liable for the billing and stuff of this, and that she was like, I don't understand why he would do me like this and stuff like that. But like, I'll say like a couple of hours after we left the house, she must have said something to someone, because we got a phone call, and this was the best lead we had on him yet.
All right, and so I guess you said it was 6 months after the case started.
Yeah,
So
it was about 6 or 7 months after.
would that make it going from 2024 to 2025 then?
Yes.
All right, so this is a 6-month process that you're still investigating to find out where Mr. Hopper is?
Yes, and we were constantly working the case.
Okay, it's not just, 6 months, pack it in, who cares, we don't know where he is?
No, I don't stop.
Okay.
Even after we, at some point the courts won't give back a remit or something like that, I still continue to look for them, and we've turned people in before and they got remits and stuff like that.
Okay, and so then you get a call a couple hours after you talk to the baby mama, or somebody calls you, is that correct?
Yes, after we went to his mother's house.
All right, then what happens after you get this information? What is the information you gather?
This person, I don't know, still don't know who she was, but she wouldn't give me her name. She gave me her number. I kept contacting her. She gave us the biggest lead that we had thus far. She had verified that he was going back and forth to New York to fights with the brother. She actually gave us the brother's current, like his actual address he was at. She verified the warrants that the probation violations that the brother had, and she also verified that he was staying there, but he was going back and forth to Steubenville selling drugs. But when the brother's house, we didn't hit the brother's house because she called us back and said that the mom or somebody must have told him that we were coming there or looking for him, because she said that he had left the house. He called an Uber and he left and went somewhere, but she was gonna try to locate and let me know where he was at.
Okay, and so then what happens after that? After they realize that maybe that's a dead end at the brother's house, what do you do at that particular point?
Well, it really wasn't a dead end, because she said that he was coming back and forth, and he was still leaving back and forth out of town with the brother to go, I don't know what they were going to do, vacation or whatever they were doing. But she gave me a phone number on him. So I ran a search on the phone number I had on him. When I ran a search on the phone number I had on him, it came to I can't think of the guy's name. It was an older guy that stayed in Steubenville. So in our eyes, me and my guy's eyes, that's probably the place that he's staying at in Steubenville.
Okay, and so then what did you do when you realized that he was coming back and forth to Steubenville?
Well, we had people watching the house where the brother was staying at, because we verified that the brother was definitely staying there and that he was back and forth.
Are you talking about the house in Cleveland or
Well,
a
it
house
was
in Steubenville?
in Cleveland. This was
Okay.
in Euclid, Ohio.
Okay, all right, so you didn't just give up because the brother's house, maybe someone told you a fib or said, hey, look, they tipped you off, you don't just accept that as...
No, because the person, whoever this person was giving this information, she was basically wrapping him up in a bow for us. So she said, I will let you know when he's in Steubenville, I'll let you know when he's in Euclid. We were watching the house in Euclid. We'd already made plans to go down to Steubenville several times. We went down there once to pretty much just, since it's a little town, we went down there to drive through and sit in certain spots and do like different surveillance and stuff to see what we see. If we saw him, we were gonna grab him, but we didn't see anything. So basically, we were actually gonna spend like we said we were gonna go down to Steubenville for 2 to 3 days. And before we can even go back there, he was arrested.
All right, and so tell us, so Steubenville Police Department arrested him?
Correct.
Okay, did you have any contact with Steubenville Police Department?
Yes, I got an alert on Watchdog, which is an IRB engine search that we use. And it showed that he was arrested. And then I pulled up the information that showed that he was arrested in Steubenville. I called Steubenville. They said he was arrested for, I think it was drug possession. If I'm not 100%, but I'm pretty sure they said it was drug possession.
Okay.
So I told him that we had a warrant for him through Lake County, and he said, he'll be given a bond, and he'll probably be released if no holders is put on him, because he said they didn't have any holders or whatever on him. So I called Lake County, and I explained to him that the guy, Cortez Hopper, was in Steubenville jail. He had just been arrested earlier that day.
Who in Lake County do you call? Do you just call the clerk, or do you call the judge's office, or who did you call?
No, this was actually in the evening time, so I actually called the, I think I called the jail.
Okay, the Lake County Sheriff's?
Yeah, the sheriff.
Okay, so you contacted Lake County Sheriff's Department, you told them, what did you tell them?
I basically told them that it's a Cortez Hopper that's in jail in Steubenville, and Steubenville said that he doesn't have a holder or anything on him, and they're actually supposed to be issuing him a bond because he had drug possession. And I know there's been a lot of cases where they'll get a bond like that and be gone before the holder is even issued on in certain areas.
All right, so what did you do? You contacted Lake County Sheriff's Department to notify them so they could institute a bond or contact Steubenville?
Well, I was in contact with both of them until Steubenville said that Lake County needed to send the holder over and they would hold him. I called Lake County back, said that they didn't have a holder. Lake County said they were sending a holder over for him so that he wouldn't be released. So
So, but for your actions, is it your opinion that Steubenville would have released Mr. Hopper back out into the public?
That was my fear, because I've seen it happen a lot of times in the past when we've had cases in other areas, or if we had cases with someone out of town or something.
And because you contacted Lake County Sheriff's Department, they sent down the holder to Steubenville, is that your understanding?
Right, because if they wouldn't have sent out, I'd actually contacted Ms. Johnson, and I told her, I said, well, do you want me to head down there now, or, because I was, regardless of the fact I was gonna be there, if they didn't send the holder down, I was gonna make sure I was there. Me and some of my guys was there when they released him from the jail down there so we could take him in custody.
So were you and part of your team heading down to Steubenville regardless to say, hey, look, we're gonna go get him if?
Well, we actually were already going down there that weekend anyway. I think this was on I think it was on a Friday that I got the alert that he was arrested. We were already planning on going down there and spending like 2 days down there because the informant had already told us that she thought he was down there, but she said she would actually put us right on top of him. Because I told her I didn't want to go back down there unless she knew exactly where he was at. She didn't know an actual address. I never told her the address I had because I try not to tip my hand fully to him. But we were pretty sure if he wasn't at that actual address, he was in that area somewhere. So my idea, if we would have went back down there and let the police department know that we were in the area like we used to do when we were looking for him, we would have got him if we would have got a call from him.
All right, so let's back up to Steubenville has him, they don't see a holder, they don't know that he's wanted or has a warrant out of Lake County. You then make a number of calls back and forth between Lake County and Steubenville.
Yeah, because Steubenville pretty much was, at first they didn't even know they had him, they couldn't find him in custody. So I kept telling them, like, well, I have an alert that he's in custody there. They was like, well, we don't have a Cortez Hopper here. So they transferred me to about 3 different people until I finally got the right person. They was like, he was here, and they was like, yeah, he'll probably have a bond first thing in the morning or something like that.
So it's a situation where just because someone told you, you got information that you considered reliable, someone at Steubenville says, no, we don't have that person, you continued on trying to make sure and verify whose information was correct, whether the information that he was arrested or they don't have him.
Right. If I get an alert that someone's been arrested in Watchdog, that person's arrested. It usually gives me the arresting agency, and it gives the phone number and everything.
All right. And so you and your team are on there, you're contacting, you're making calls as you're in the car driving down?
Actually, we wasn't driving down yet, but my bags and stuff were packed because we were going down there anyway.
Okay. And so then ultimately, does Steubenville decide to hold him because Lake County then sends down the holder?
Yes, I'm assuming that was the case because they didn't have a holder on him at first.
Okay. And so then at some point, was Mr. Hopper released from Steubenville?
He was actually, a holder was put on him and he was brought back to Lake County.
All right. So he posted whatever bond or Steubenville released him on whatever charge they had for him.
Right.
And then the only reason he was not released was based on your efforts in Lake County sending down a hold to Steubenville saying, there's a warrant out of Lake County, hold him, we'll come pick him up.
And from the conversations that we had, that I had with Steubenville and Lake County, I'm gonna say yes.
Okay. And was there anything that prevented you, were you gonna go down and pick him up?
Yeah, if they wouldn't have issued a holder, and I've done this I've driven out of town several times to pick up people if a holder wasn't issued.
Now, did Lake County say that they were gonna go down and pick him up, or did you say, hey, look, I'm going down there, I got my bags packed, I'll go pick him up if you need to?
No, it doesn't really work like that. Once they issue a holder against them, then they automatically, he's not going nowhere unless they lift the holder for some reason.
Okay, so even if you wanted to, you couldn't have actually obtained Mr. Hopper's body and brought him back and turned him in personally to the Lake County Jail?
Yeah, well, if they wouldn't have issued a holder on him, yes.
Right, I'm saying now, we know that Lake County's issued the holder, Steubenville knows that the holder exists. Is there any situation where you as a bail recovery agent could go down to Steubenville and say, gentlemen, release Mr. Hopper, I've got a bond out for him, there's a bond forfeiture, I need to personally bring him back to Lake County, otherwise I may lose this bond?
Right. The only way I can do that is if they, at that point, if they lift the holder or they say, we're not picking him up, then we can pick him up at that point.
Okay, And was it your understanding that Lake County was going down to pick him up?
Yes,
Okay, and so, but for your actions, Mr. Hopper would have been released back out into the community.
yes, I would
Okay.
assume so.
And so then, at some point, did Mr. Hopper, I assume Lake County went down to pick him up, Lake County Sheriff's Office went down to Steubenville to pick Mr. Hopper up and then bring him back to the Lake County Jail.
Yes,
And that's where Mr. Hopper currently is residing, in the Lake County Jail.
I think so.
Okay. I have nothing further, Your Honor.
Mr. Gagich, your question, the witness?
Yeah, just real briefly, Your Honor. Prior to the defendant's arrest, did you provide any information to the Steubenville Police Department?
No, actually, this was, the information, I think the informant might even told him that he was down there, because whoever this was giving me information, they wanted him.
So you didn't call Steubenville ahead and say, hey, this is where his address is, or anything like that?
No, I
Okay,
actually went
nothing.
down there
Thank
and
you.
looked.
Any follow-up?
Yeah. The individual that gave you the information, did you tell that individual that he was wanted?
No, they didn't.
I'm talking about the confidential source who was giving you the information.
No, they actually knew he was wanted when they
Okay.
called me.
All right, and so did you tell them that, did you talk to them about the bond and that you were trying to get him and find him?
Yes,
And you were doing everything you could to get him?
yes, and whoever this was, they knew. That's why I was wondering if I still think they might have said something to the police department down there, because they knew, whoever it was knew where he was at, but it's like they wanted to breadcrumb feed me, because they didn't want him to know that it was whoever was giving me this information.
All right.
Because I guess very few people knew how he actually was moving around, and this person knew every angle how he was moving around at that point. So
All right.
I assume they knew the address he was at down there.
And based on what you shared with this individual, however much or however little, they were gonna do whatever they could to get Mr. Hopper apprehended.
Yes.
I have no further questions.
Any recross?
Nothing, Your Honor.
Okay, thank you, sir. Ms. Karski, anything else you care to have this court consider?
Do
Evidence-wise, any other testimony?
you want to testify? No, nothing further, Your Honor.
Mr. Gagich for the state?
Thank you, Your Honor. We'd like to call Detective Wren.
Detective, you can stand for one, you can stay up there, but I'm gonna have you raise your right hand. You swear this testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, you can be seated right there. Just keep your voice up so everyone can hear.
Could you state your name, spell your last name for the record, please?
Dominic Wren, H-R-E-N,
And where are you employed at?
Lake County Sheriff's Office.
And what do you do there?
I'm a detective and also assigned to the United States Marshals Fugitive Task Force.
And were you, as part of your job on the task force, were you involved in the search for Cortez Hopper?
Yes.
And can you tell us what you did?
Yes, it was a case that we adopted. It was actually assigned to a different TFO, task force officer. But I don't recall the date, but I do know that Task Force Officer Robertson drove down to Steubenville with the intention to do surveillance on Cortez Hopper. He had received some information that he was staying at an apartment complex in Steubenville. While down there, he observed Cortez Hopper. He showed a couple photographs to management, I believe, and I don't know. Again, I don't know at that point if they contacted local police or how it became involved, but somehow Josh became aware that Steubenville had
Who's
Josh Robertson, Task Force Officer Robertson. Yes, sorry. He became aware that Steubenville PD had an ongoing narcotics investigation case going. One of the subjects of their investigation was an unidentified male to them. Through their coordination, Josh showed him a picture. He was able to actually identify Cortez Hopper to Steubenville. At that point, given how far Steubenville was from Lake County, we made the decision to, and I don't recall if we used the Southern District of Ohio Marshal Service or if we used the Northern District of West Virginia. There was some back and forth because of the location. But either way, one of those task forces sent some manpower and assisted Josh in apprehending Cortez Hopper at this apartment complex in Steubenville.
I think that when we spoke about this, you indicated that they were able to use social media to locate him.
Yes, that was part of it.
Was that provided to you by who?
That was done through Josh's investigation. He was able to locate some social media accounts, which led him to Steubenville.
And were you informed from the bonding company any information?
Not to my knowledge, no.
Nothing further, thank you. And the task force arrested him, not Steubenville, is that
Correct.
correct? Nothing further.
Before you cross, let me ask questions, then you can maybe both clear up. So the deputy or Detective Robertson was involved in the actual arrest of the defendant?
Yes, he was the only member from our task force that was present because it was his case. He drove down to Steubenville just with the intention to do surveillance. And once he was able to get eyes on Mr. Hopper, he was coordinating with our boss, and then the decision was made to use manpower who was closer in proximity to Steubenville. So I don't know if it was the Northern District of West Virginia or if it was the Southern District of Ohio. There was some back and forth, so I don't remember off the top of my head which one
Was
they used.
Detective Robertson physically there, though, for the
Yes,
arrest?
he was present.
And he's a part of this task force?
Yes, he is.
But he's also a Lake County Sheriff's detective?
He's a Lake County Sheriff's Office deputy, and then he's assigned to the task force as well.
And he was actually part of the physical arrest of the defendant?
Yes.
Any other, you want to follow up with that at all?
Yes.
Nothing.
Cross-examination.
Yes, thank you. Detective Wren, did you or who brought Mr. Hopper back to Cleveland or Lake County?
I believe he was housed locally in Steubenville, and typically we would have some members of our court services at some point coordinate with Steubenville to bring him back. I don't know who physically brought him
All
back.
right. So if I understand what your testimony is, the Steubenville Police Department was doing a drug investigation on Mr. Hopper, but they had not arrested him for any drug-related matter.
To my knowledge, I don't know what jurisdiction it was. I don't know if it was a sheriff's office, a task force, local PD. There was an ongoing narcotics investigation. When Josh was down there in Steubenville, there was some communication between local police, and Josh knew Cortez from his investigation, and that actually, whoever was working down there, he showed a picture, they discussed it, and they said, oh, this is the target of our drug investigation, we don't know who he is. So then they realized that was Cortez Hopper, and at that point, the Marshal Service assisted in arresting him.
And Detective Robertson is the point of all the investigation, so he knows all of the individuals and how he got the information as to why it's down in Steubenville.
Yes.
Okay, and you weren't part of that investigation, or you don't know all that information?
So I'm familiar with it, I wasn't present for the arrest,
Okay,
though.
and so you don't know the source of the information from Detective Robertson as to why he decided to go down to Steubenville?
I do know the source of the information.
Okay, was it a female?
No, it was his own investigation. It was through using his. It was not. It was his own investigation.
Okay,
That
so
got the information.
there was no, is it your testimony then that there's no live or source information? It's all just looking at paperwork, looking on the computer, that's it? That's how we found out everything?
Yeah, to my knowledge, there was not a person as a. It was not a
Right.
human being as a source.
So is it your testimony then that Mr. Hopper puts on his Facebook or social media, I am staying at 123 Main Street, and you can come get me if you want?
No.
Okay, and so you have to do more than that, you actually have to have some live person or live source to tell you, it's over that house, the White House over there, that's where he is?
No.
Okay, so are you using other technology to use IP addresses wherever someone's posting that you know the general area?
Typically, yes.
Okay, so that's how you ultimately found where Mr. Hopper was as far as down in Steubenville.
Yes.
Postings from social media, IP addresses to say, yes, this is the general area, or this is the house, or this is the internet provider that he is using.
Yes.
Okay, and so that's how you got down to Steubenville, correct?
Yes.
All right, now, Detective Robertson then affects the arrest of Mr. Hopper, is that correct?
They utilized again one of the task forces that was closer down there with the marshals. I don't know who.
Southern District, West Virginia, wherever, somebody arrested him.
Yes.
But Detective Robertson was down there.
Yes.
Okay, now, at that point, had Steubenville charged him with any criminal offense?
I don't know.
Okay, so, Detective Robertson had to return back to Lake County, correct?
Correct.
All right. And in fact, he doesn't take Mr. Robertson back with him, does he?
Well, it's outside. There'd have to be a Rule 4, so it's out. It's too far. So I believe they housed him locally and Josh returned here, and then there was, again, I don't know when he came back, when Cortez came back,
Okay. And you heard the testimony from Mr. Nunn, correct?
most of it.
Okay. And in fact, there wasn't a holder placed on him at that time until Mr. Nunn was taken into custody?
I have no knowledge of that.
All right. And so do you know if Mr. Nunn contacting the Lake County Sheriff's Department, that caused the holder to be placed on Mr. Copper?
I have no idea.
Okay. I have no further questions, Your Honor.
The task force only arrests people with outstanding warrants, is that correct?
Correct.
You don't do a drug investigation, the marshals do not do drug investigations. So obviously there had to be a warrant for the U.S. Marshal Service to have a case.
Correct.
Nothing further.
Detective, when did you become aware that there was a warrant for Mr. Hopper?
Whenever it was issued, we adopted it as a case. Since it was through Lake County, we looked through the warrants and adopted him as a case. I don't know the date.
So I think it was somewhere around, let me see, in July 3rd?
July 3rd.
Yeah, July 3rd, it was ordered. That's when your office became aware of it?
I don't know when we became aware of it. I mean, sometimes we become aware of it months and months after, sometimes it's day of it. It just depends on when.
Right. I've asked you, when you started the investigation looking for Mr. Hopper, and you said it was immediately upon the warrant being issued?
No, I don't know when we became, there was a warrant issued, and at some point after that, we began investigating. I don't know when afterwards.
Okay. And so, if you have all the resources of the federal government and Lake County Sheriff's Department, and you're looking at all this technology, you would have been able to find him, maybe, I guess, by August, if you could follow his social media.
Again, I don't know when we adopted the case. Sometimes these investigations take weeks, months, years, so I don't know how long we were investigating him.
So your testimony is that there are times that people actually can go out and be gone for years. I think that's what your testimony was?
It's possible.
All right. And you have resources that other individuals, that private citizens don't have access to, correct?
Yes.
Okay. And you can use those resources to find the individual?
They assisted, yes,
Okay.
yes.
And so it's not that the bonding company didn't do anything, they were actually effectively looking for Mr. Hopper, but you have additional resources?
I don't know what the bonding company did.
Okay.
Skygerich, any further witnesses? Skygerich?
No, Your Honor.
Sorry.
I was just thinking about that, I'm sorry.
Mr. Kowarski, you care to make any comments? I will say, I want to, in regards to the first argument you made, how was it that you learned that the first hearing was canceled?
Mr. Ingersoll submitted an affidavit indicating that he did not get notice of that. This is the second, I'm sorry, it's the second.
I'm talking about the first hearing. How did he know the first hearing was canceled?
That I'm not sure.
Oh, may I speak?
Sure.
Because
Yeah.
We had a hearing set. He filed a motion to continue that. How'd you learn that that was canceled?
So, my name is Penny Johnson, Pennie Johnson, Johnsson. I work for City Bonding, I handle bond forfeitures. When we received the motion, I calendared them. I reached out to Mr. Ingersoll. I said, we have a hearing coming up on whatever day it was. We're still looking for him. We haven't located him. We need to get a stay execution of the bond judgment. Mr. Ingersoll filed the motion. Once it's in his possession, I let him handle that. Then I received
It's the court's fault.
No.
I guess I want to know how you
Well,
knew
hold
that.
on.
How do you know the first hearing was
Okay,
canceled?
because then we received a notification from the court,
Okay.
okay?
And that notification from the court said the hearing's canceled and continued to October 7th.
No, that,
Yeah, no, it does. I'm
well,
looking
I
at it.
didn't receive, so, but I
I
understand
mean, the
exactly
hearing
what
that
you're
canceled the
saying.
first hearing, the order that canceled the first hearing
It did not.
set the second hearing in the same order.
So there was this,
And then you filed a motion to continue the
This-
second hearing. So you had to
so-
know there was a second hearing to continue a second hearing.
so, but on that date, the October 7th hearing, we didn't receive this one, the November, it's dated, what?
If nobody showed up for the October 7th hearing.
I didn't know about the
Well,
October 7th.
it was in the
hearing.
order granting the continuance of
Okay.
the first one.
So,
The first one, when nobody showed up, so you guys knew about it,
Okay.
because nobody showed up for it, set the second hearing in the same order.
so I'm just going by what Mr. Ingersoll.
All right, well,
and-
then you need to straighten this out with Mr. Ingersoll. He was notified.
Okay.
Well, you don't
So
noti-
he did an affidavit stating that he never received a ruling on the September 13th notice. So that's, including the numerous emails from the court archived.
Well, then why didn't he show up? It was
So-
set for October 7th. If he didn't receive a ruling, why wasn't he here?
Well, physically, medically, he cannot.
Why wasn't he here for,
physically
he didn't call? He didn't say, you know what? It's September 6th today, or October 6th today.
That-
I have a scheduled hearing tomorrow, and I haven't received a notice that it was canceled. So,
I
is it
can't-
canceled or should I be there?
I can't speak on
can't.
Mr. Ingersoll. I can only speak on what we have in our possession.
Well, I'm telling you that the order that continued the first hearing, which you received because nobody showed up for it and you knew it was granted, set the second hearing for October 7th. Now, he filed a motion to continue that October 7th hearing. Now, you said nobody even knew about the October 7th hearing. Now we're saying that he did know about it, but he filed a motion to continue that and never received notice that that was denied.
That there was any ruling on it, correct.
All right, well,
So
then you
why
knew
he-
about the October
So why
7th.
he did it, I don't know.
Well, you knew about the October 7th hearing, though.
I personally did not know until I printed out the docket for this hearing. And that's why I reached out to Mr. Ingersoll saying, I never received this October 7th date. He said he went through his archives and he didn't know. So I,
Well, he's
I
lying
know,
because
I know
the
exactly
order
what
granting
you're
the
saying.
continuance of the first one set the second
I
one right in the
understand,
same
but
order.
I can only go by
And then he
what
filed a
I
motion to
have.
continue the October 7th hearing.
Okay.
So,
Yeah, I don't know what Mr. Ingersoll.
I know you don't. I'm
So,
not
yeah,
holding
and-
you to that. You just got on board here. I get all that. It has nothing to do with Mr. Kularski. I just trying to argue that you didn't know about this October 7th hearing when you're supposed to be here.
And I know Mr.
After I granted a first extension. I will tell you, I will never grant a first extension anymore then, because if there's gonna be, issues with not getting notice of a second hearing, then I'm not gonna
No, and I
deal with
understand.
that.
And with all due respect, I know Mr. Ingersoll has had serious health conditions, so I don't know at that time what was going on with
And
him,
that's-
to be honest with you. I mean, I'm not gonna make up those excuses, but
That doesn't
we
get
would
Mr.
never
Hopper in
disrespect
the
the
court.
court like that, so
All right, well, the court will take this matter under advisement and issue a ruling.
I
Anything else
appreciate
for the
that.
record?
Nothing, Eric, thank you.
Nothing, Your Honor.
We are hearing case 23 CR 435, State of Ohio versus Bryce Volpe. Motion to terminate the defendant's community control sanctions is previously filed. Defendant previously waived probable cause. We're here for a final hearing. Defendant is here in court with counsel Mr. John Patika. Mr. Patika, what's the defendant's intention at this time?
Good morning, Your Honor. I've discussed this matter with Mr. Volpe. He'd like to waive his final hearing, plead guilty to both of the violations, and resolve them today.
Mr. Volpe, you've been charged with violating the conditions of your community control sanctions. First off, it's alleged you violated Rule 11, which requires you to comply with all special conditions set forth by the court. And you were specifically ordered in this case to pay restitution to the two victims in this matter, David Meadows in the amount of $200 and James Giles in the amount of $2,185, and that you have failed to comply with that order. It's further alleged that you violated Rule 3, which requires you to report at such times and places as directed by your probation officer, and you were directed to report on May 16th, and you failed to do that. Now, you have the right to have a final hearing on these allegations, which is a hearing where the state would be required to prove the merits of what they're alleging. You could have this hearing, but you can also waive the hearing and plead guilty. Your attorney has indicated he believes that's what you want to do, waive the hearing and plead guilty. Is that correct?
Yes, that's correct.
Well, before I can accept your waiver and your admission to the violations, I need to make sure you understand the potential penalties you face if you're found to have violated. If, in fact, that were to occur, the court could extend your probation up to 5 years. It was originally 2 years, so I could extend it up to another 3 years. I can impose more restrictive sanctions against you, including an order that you serve more time in our jail, or I could terminate your probation and send you to prison. And if I did that, it could be 9, 12, 18, 24, 30, or 36 months on count 2, anywhere between 6 to 18 months on count, the 9, 12, 18, 24, 30, or 36 is on count 1. The 6 to 18 months is on count 2. That could be consecutive for a total of 54 months or 4.5 years in prison. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, I do.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violation?
I'd like to waive the hearing and plead guilty to the violation.
Very well. As the allegation that you violated Rule 11 by not making restitution as ordered to do so, what is your plea to that?
Guilty.
As to the allegation that you violated Rule 3 by failing to report on May 16th of this year, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions. Mr. Patika, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I would, Your Honor. I had an opportunity to meet with Mr. Volpe last week at the jail. Stressed to him that if he is given another opportunity on probation, that this has to be a top priority. We also talked about the truth, untruth, and misunderstandings. I think
Misunderstandings? All right,
Well-
you can call it that, I guess.
in court, you're either telling the truth, you're lying, or there's a misunderstanding of some kind. In general, not pertaining to this case. But we talked about his need to be absolutely transparent and truthful going forward if he's given another opportunity. We talked about the fact that he's not the person in charge. He's got to do what he's told. I believe he understands that. From January of this year through May, he was working for his AA sponsor, painting under the table. He did not think that, he didn't want to tell you that at the prior hearing. Wasn't clear to me why not. But he has been working under the table. He's been doing some door dancing.
Why didn't he tell his probation officer that? Well, he can
don't know.
answer these questions, but.
But we're asking that the court consider giving him another chance at community control, give him an opportunity to pay off the restitution that's owed, and put this case behind
Mr. Volpe, you have the right to address this court before you're sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
Go ahead.
I just wanted to say, I've had a lot of time over the past 2 weeks to sit in jail and think about where I went wrong with all of this and how I can fix it if I'm given another opportunity. I also learned that there's no such thing as a good excuse for any of my actions. If I'm given the opportunity to continue with probation, I'll make sure I'm at every meeting that I need to be at. I'll answer my phone anytime I get a phone call from probation. And most importantly, the restitution, I can start working again as soon as I get out of jail, and every penny that I make will go towards paying that family back.
Well, when you were here last time, you said you could pay it off right now. You could have paid it off that day. Or is that a lie too?
It wasn't a lie, I just don't want to have to make my family help me if I can do it myself. But if I have to...
So you couldn't have paid it off that day. Your family could have paid it off that day.
Well, yeah, yes, you're right.
Go ahead.
I just also wanted to apologize to you for even having to come back to court in the first place. If I was able to apologize to the victims of my case for not paying their restitution back on time, I wish I was able to do that as well. And just to apologize to my probation officer for not being truthful with her and not doing what I was supposed to do.
All right, thank you. Mr. Fatika, anything else?
No, thank you, Your Honor.
This court reviewed the pre-sentence report and investigation. Consider the facts and circumstances of the underlying offense that brought us here initially, the nature of that offense. I've considered what's been said here in court. I've considered the nature of the probation violations. I received an additional victim impact statement from the victim in this case for the probation violation. I've done this for 21 years. I've never done that, had that happen before, but I got a victim impact statement from the victim on a probation violation. I've read and considered that. I've considered the defendant's performance on probation. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, I'll incorporate all the findings I've made at the time of the original sentencing hearing regarding the seriousness factors and the recidivism factors, with the additional finding that the defendant did fail to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. And any other relevant factors. In this case, I find that the defendant has continuously been perpetrating a lie to our probation department, very elaborate lies that he just continues going with. Flat out lied to me in court when he was here last time, telling me he was working at this company and he'll be able to provide proof of the employment and all that, and it's just all lies. And if you're able to do that, you're able to lie to your probation officer continuously and come up with the elaborate lies that you did, you're able to lie flat out to me and looking at me in the eyes in the courtroom, those are factors indicating recidivism is more likely. Nothing makes it less likely. You know, when you were here the first time, Mr. Volpe, you got a big break. You did no jail time. You had 10 days in, I think, and I gave you credit for that, and then no other jail time. And you finished that program, and I'm happy about that. And then you just started playing games with the probation department. And again, multiple lies to them about working. You worked for that company for a week. And you led her to believe that up until even recently, you're still working there. As indicated, you lied here in court. You were doing what you wanted to do. You weren't showing up at probation when you were supposed to, calling her on all off work hours with excuses, not going to say excuses, with lies. That's not how, you're not going to succeed in probation if that's how you plan on doing this. And that's what you've been doing for the last year. haven't paid the restitution. Why should these victims not get their money back? You stole from them.
They should get it back.
Well, right, and that's why you were put on probation to do that, and you haven't done that. So why should I continue on probation? I mean, I want them to get their money back, but if that's not gonna happen, then
It will happen.
you're getting a break, and the victims are still suffering. But you've got work on your way of thinking. I will find at this time that prison will not be consistent with the purposes and principles of sentencing, that you're amenable, but we're gonna give you some help with your thinking. I'm gonna order that you serve 60 days in jail. I'm gonna order that you have 14 days of credit. I'm gonna order that upon a bed becoming available at NeoCap, that you enter and successfully complete the program at NeoCap. This is gonna help you with your thinking and making good choices and right decisions. As soon as the bed's available, I'll allow you to be released from the jail to go to NeoCap. Any remaining jail time will be vacated. You're successfully complete NeoCap. Upon completion of NeoCap, you are to return to jail. You may not have to do this, we'll see, but for 30 days in the Transitional Day Reporting Program. What that is, it's a program that helps people make the transition from being in custody to being on their own. Many people, when they get done with serving whatever time or custody that they have to serve, have nowhere to go. They have nowhere to live, no work set up. If you have that stuff in order, then I'll vacate those 30 days and you won't have to do it. And that's something you can work on. But what that means is that you have to have work lined up, verifiable work that you're not lying about. If you do, great, I want you to. If you don't, then you'll be released every day from the jail during the day to go out and look for work. And once you find it, then you'll be released from jail. But that's what that program does, helps people get work lined up, get housing lined up. I'm going to extend your community control sanctions by a total of 12 months. So till June of 2026, June 26th of 2026. Further conditions, you're not to use any drugs or alcohol. You must submit random urine screens. I'll do 3 AA meetings a week with a sponsor. You're to obtain and maintain full-time employment, verifiable employment, that you're going to verify to them by showing them pay stubs, whatever it is, every week, every 2 weeks, whatever you get paid, you're going to show them every pay stub. You are to make restitution to the two victims in this case, David Meadows in the amount of $200 and James Giles in the amount of $2,185. Any payments that you have made, you get credit for. You're to get on a payment plan and make regular payments, whatever payment plan probation works out with you. You're to do that immediately out of getting out of NeoCap, because you're not. When you get out of NeoCap, you're either going to be in jail or you're going to get a job. And once you have that job, you should need to start making these payments, and that should be immediately. So you're going to get on a payment plan and comply with that payment plan. You have no contact with any of the victims. I don't know if I said it, but I think no drugs or alcohol, random urine screens. No marijuana use. Got that? What did the mental health, was he doing a mental health counseling, Nicole?
He completed the assessment and there were no recommendations
Okay.
made.
Peer court costs and supervision fees. Nicole, anything else I should be thinking about here, or I missed?
The only thing I'm just a little worried about was the time for NeoCap. I know they said about a 40-day wait. With the credit, it leaves us at like 44 days, which I'm sure would be fine.
All right, we'll do 75 days in jail. You're not gonna have to do it. It's just to make sure we have enough time to get you to NeoCap. So 75 days in jail with 14 credit. But as soon as that bed's available, you'll be released, and you're not gonna have to do the balance of it.
Okay.
Anything else?
No, you're not.
Tika, anything?
No, thank you, Your Honor.
Mr. Volpe, I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, another motion to terminate will be filed. If it's found that you violated, I could extend your probation up to 5 years, I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I send you to prison, it would be 36 months on count 1, 18 months on count 2, consecutive, or 54 months in prison. You understand that?
Yes, I do.
And I also want to stress, you need to report to your probation officer when she tells you to report to your probation officer. You're not to call after hours, before, right up, after hours, in the middle of the night, before the day starts, right before you're supposed to show up and say you can't be there. You need to report to her as your director, or you're going to get violated. You understand that?
Yes, Your Honor.
All right. All right. Thank you.
All right.
Your Honor, we're here in the matter of the State of Ohio versus Andrea V. Wasik. This is case 24 CR 1364. Ms. Wasik is present in court. She is accompanied by her attorney, Ms. Tomasik. We are here today with the defendant having previously entered a plea of guilty to assault on a peace officer, a felony of the 4th degree. That was back on the 18th of April. At that time, the court ordered a pre-sentence investigation along with victim impact statement. Those having been accomplished, we are here today for sentencing.
Thank you, Ms. Thomas. Is there any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Anything you'd like to say on behalf of your client?
Yes, thank you, Your Honor. We would like to ask the court today to allow Ms. Wasik a chance to be put on community control sanctions. In speaking with Ms. Wasik and based on her pre-sentence report, it's clear that she has a lot of mental health issues, a lot of trauma in her life. Your Honor, she does go to Signature Health. She goes at least once a month to speak with somebody, and she is on medication. She indicated to me that she wants to pursue grief counseling and trauma counseling. It's something she's never done before. She said her prior trauma hasn't started coming up until later in her life. I know a lot of the trauma was linked to her being a teenager. She had a lot going on at that time, and she indicated to me it hasn't come up until as of late. She also indicated to me her housing situation has been very unstable, but she has been very communicative with me. She shows up to court, she shows up to offers conferences, so even with her housing situation, all the stress she has going on, she has been very responsible when it comes to this case. She knows she messed up and she wants to take care of it. She did indicate to me that she is on the path to getting housing, but she said will help with her mental health and help get that anger under control. She's looking to rent a home close to Perry, so she'll still be within the area. She did apply for housing in Lake and Geauga County, but she unfortunately was denied, and that's been her biggest hiccup. Your Honor, based on her mental health and her living situation, she's trying to get her life on track. She's trying to stay out of trouble. Last I spoke with her, she indicated she doesn't have much of an issue with alcohol. I do believe, though, that some of this has played into that, so I do think she would benefit from a dual diagnosis situation.
She said she hasn't drank in over a year.
I know, Your Honor, and I know there was some concern with the new cases coming up, and I know she has a pretty lengthy criminal history, and I know that criminal history, a lot of it leads to violent tendencies. She's been on probation before. Like I said, speaking with Ms. Wasik, I do believe mental health is her biggest underlying condition. I think if she has the ability to get that under control, she'll be able to get on a path to stay out of trouble. Thank you.
Thank you. Ms. Wasik, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Good morning, Your Honor, and the court. My name is Andrea Wasik. I'm 58 years old. I'm not making any excuses. I feel terrible for my actions. I'd like to apologize to the court system and also to the officer that I victimized. I'm not making any excuses. I've struggled with my mental health. I have gone through some jail time. I've come out. I am on Social Security. That process happened 3 years ago for mental health. I have struggled to get my medication right. I've had Bell's palsy and also Stephen-Barr syndrome from medication, so it's been a long journey. It's been a struggle. When I think sometimes that the medication is working, it will affect me differently maybe later on, and then I'll experience a physical anomaly from it. I was manic at the time of the incident. I do remember prior to the actual officer coming there, I was told by the driver what had happened in between. I do know what I experienced. I had never experienced that physically ever, but I was on a medication called Culotta at that time, and it was causing me I had an assessment on October 30th, and I believe that the incident happened on November 11th, and I was having suicidal thoughts, and the medication was not, it was not working well with me, and I'm on a lot of medication, and sometimes I don't know, I get, I was on Ambien, Trazodone, Vistarol for sleeping. I am not on that medication anymore. It had caused me to do some bizarre things that I would wake up and didn't be aware of. I do know at the time I was on Culotta that I just did an assessment on the 30th of October for approximately 3 hours with my mental health doctor, and I just stopped taking the medication because it was making me suicidal. I had suicidal tendencies, and I tried to set myself on fire, believe it or not. It didn't work out, thank God, but I was experiencing like so much of the medication. It would work for a little bit, and then, you know, I would get, I got Stephen-Barr syndrome. I got, like I said, I'm not trying to make any excuses, but if I'm stable in my housing, my Social Security has been cut off since then. I'm doing odd jobs to try to support myself, and I applied for housing in Lake County, and I was denied in Lake County and Geauga because of this. They sent me the records from Lake County. So I just applied for housing down the street in Perry so I could be close if possible, and to reconnect with other services like trauma services that I've talked to my counselor prior to this incident happening. And I was going to go to grief counseling at St. Anthony of Padua's, but I've never had that before. I've never had that, and I know I need it because these things are coming up from my past when I was younger, and it's affecting my life horribly now. And when I was a teenager, I had my parents and my family, and you know, I had more of a solid support group. You know, everybody is gone, and it's just me. And I've tried to work out things with my counselor, and you know, try to go do the best that I can. Go to IOP. I was going to IOP.
Your parents passed away
Pardon?
almost 27 years ago. Your mother passed away
Yes.
14 years ago.
Yes, yes. And I just had a sister, my best friend, my closest person 2 years ago, and that trauma of that, I've never, you know.
I'm trying to figure out how that has to do with this when it's so long
Well,
ago.
the medication, like I said, I'm experiencing things that I've never experienced in my prior life. I have been going to.
Prior life, you have prior life?
I mean, I'm sorry, my prior, younger, when I was younger. My sister passed away 2 years ago, and I've struggled with that immensely. Of, you know, she had a severe mental illness also, and,
Ms. Swansek, you've been committing crimes for 30 years.
pardon me,
You've been committing crimes for 30 years.
30?
Yeah, 1995 it started. 30 years.
I was like 36 years old when I started developing, things that I wasn't sure what was going on
You were
in my
28
head.
years old when you started committing crimes.
28,
30 years ago. How old are you now?
58.
All right.
I don't remember them, but
You don't remember a lot.
I don't. I'm severely, I apologize to the courts and to the officer. Please present.
Anything else you'd like to say?
Please have mercy on me, please, and give me a chance. I could do probation. I know I can.
You've never done it. You ever on it, you violate every single time. You're on probation when you did this.
Yes, I was on probation for a DUI 3 years prior to that. Yes, I was. Your
Right, I
Honor.
mean, so you say you
Yes,
can
sir.
do it. You've never done it successfully.
Can you give me a chance to, please? I successfully completed a couple programs, CATS, Neo CAP, Orca House. I successfully completed those. Neo CAP twice. I know I can do this.
I don't know
I
how you
have
know
to
you
get
can do it.
Stable on my medication and my housing, and I know I can do it. I'm even willing to do, you know, restitution to the police department if that's needed. I will do whatever I can. You know, whatever. I think I've never been given a chance, and I don't know much about it. I
You've
know
never been
people-
given a chance?
No, I'm saying I've never been given a chance to be on the mental health docket. I need help to help myself. I can't do it all by myself because sometimes things get jumbled and I get too overwhelmed. And if I can bounce it off somebody else, like my counselor, you know, at times I bounce it off of her or Eric from IOP or somebody else, then they give me insight on it, and then I can focus and think a better option or way of doing things. I've never been given the chance to be on the mental health docket. I think that would be very helpful to me, that I have to be accountable for certain things that are told that I have to do. I struggle to get to places, but I can do it. I can do it. And when I have more of a structure in my life, I work better. I do better. I want to do better. I want to have a better life. I want to be a part of the productive part of the society, not the destructive part of society. When I moved over here, I was doing wonderful. I felt good. I had people that were suggesting things to me that I looked at a different perspective, and I was doing them. You know, I want to be a productive, positive part of society, not a negative part of society. You know, I want to acculate into a community. I want to be a part of the community. I volunteered at the senior center. I loved it. I volunteered at the senior center. I volunteered at the churches here, St. Mary's and St. James, the Hunger Center. I mean, the more I do things like that, the better I feel and the more structured I feel. I need to get stable on medication. I've taken so much medication that sometimes I don't know if I'm coming or going, to be honest with you. And when things happen to me, like I'm waking up, putting plates in the microwave and, doing stuff like that, the medication is not good for me, but it's hit or miss. I take so much medication sometimes that, sometimes it has an ill effect on me, sometimes it has a good effect on me. I mean, I would like to be stable in my life and, like I said, be a positive part of society and apologize to the court system and to the officer. I really apologize for my actions. Sincerely. Sincerely.
All right, thank you.
Thank you.
Tom, is there anything else?
Nothing further, Your Honor. Thank you.
Mulligan.
Your Honor, at the time of the plea, the state agreed to recommend community control, and at this juncture, I'm obligated to stand by that recommendation.
This court reviewed the pre-sentence report investigation, the psychological evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here in court today. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. As for the recidivism factors, almost every factor here is present indicating recidivism is more likely. The defendant committed this offense while she was on probation to another court. She has a lengthy history of criminal convictions going back to 1995. And the nature of those convictions are all the same thing we're here for. They're offenses of violence. Second time I've said this today, but I've been doing this for 20 years. I've never seen somebody with as many convictions for assaults and battery and it's not even close as Ms. What were the numbers that you had, Megan? You had 30 arrests, or no, how many arrests for assaulting a police officer?
Charges total 10, the convictions total 7.
And then total assault charges, 30?
Charges of violence, I totaled at 30 with 15 convictions.
Incredible. 30 arrests. Was that 30 plus the 10 for this, or that includes those?
No, the 30.
30 arrests for assaults and batteries. That doesn't count any of the disorderly conduct charges. 30 arrests for offenses of violence. Incredible. You've not responded favorably to previously imposed sanctions. You've been given multiple chances. Multiple times you've been on probation, and every time you're on probation, you violate. You don't follow the rules. You don't do what you're supposed to do. You pick up new charges. That's a big one. You were on probation at the time you did this. While you're on bond in this case, you've been arrested on another charge, which is pending right now in Ashtabula County. There's an alcohol problem relates to the offense, and you deny it. You claim that you've been sober since April of 24. Yet, in this case, there was alcohol smelled on your breath. In the new case pending in Ashtabula, there was alcohol that was smelled about your person. In this case, there's no genuine remorse. You can stand up here and say you apologize, but you don't even admit what you did. You say you don't remember anything. Now, you remember every specific detail, up until the moment that you get into it with the police officer, and all of a sudden your mind goes blank and you don't remember anything after that. But you weren't drunk, you weren't drinking, according to you. That's just not credible. It's not believable. So that's every factor in the recidivism more likely, which basically to me it's guaranteed. There's no factors indicating recidivism is less likely. Under 2913B1, the court finds the defendant previously served a prison term. I forgot to mention that earlier. She committed the offense while she was on community control or probation. The offense involved physical harm to another. She has a prior conviction for causing harm. Those are all factors overriding any presumption for community control sanctions. Prison's consistent with the purposes and principles of sentencing. There's just no way this court could ever make a finding that you're amenable to community control sanctions. You're not. You've demonstrated that. I don't know, you stand here and say, I know I could do it. I don't know how you could say, I know I can do it, because you've never done it. And you're just going to continue engaging in this behavior, because that's what you do. It doesn't matter what anyone says or anyone does. You just continue to assault police officers, assault others, drink and get out of control. That's what you've been doing for 30 years, and you haven't done anything to change it. Therefore, it will be the sentence of this court that on count 1, defendant served a term in prison of 10 months. She has credit for 3 days. Counts 2 and 3 will be dismissed. I need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 5 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in any program of shock incarceration, intensive prison program, or transfer to transitional control. And the defendant's ordered to pay all costs incurred in this action. Ms. Mulligan, is there anything else for the record at this time?
No, Your Honor, thank you.
Ms. Thomas,
No, Your Honor, thank you.
We are here in the case of State of Ohio versus Tyrone Merritt, case number 24 CR 970. Defendant is present in the courtroom and represented by defense counsel. We're here today for an anticipated change of plea in the case. State's offer is an amended count 1, attempted felonious assault felony of the 3rd degree. There is no commitment or recommendation for sentencing at this time. It's my understanding that the defendant is going to take that offer today.
Thank you. Mr. Watson, is that correct?
Thank you, Your Honor. May it please the court, that is my understanding of this afternoon's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I do believe full discovery has been provided. I've also had ample opportunity to discuss this matter with Mr. Merritt. He has indicated to me that he is prepared this afternoon to enter a change of plea as outlined. He understands that by doing so, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. Mr. Merritt, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this afternoon?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to a lesser or reduced charge of count 1 being attempted felonious assault, a felony of the 3rd degree. Court would then defer sentencing to a later day to get some reports completed, come back on a future day where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you would like a moment to talk with your lawyer to ask him questions, or even if you ask me questions, make sure you let me know that, because I need to make sure you understand everything going on here, all right?
Yes.
All right. Well, let's get started then. How old are you, sir?
32 years old.
Are you able to read and write the English language?
Yes.
Any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, you should have received a copy of the indictment that was filed in this case. That's the document that sets forth the specific charge you're accused of committing. Do you remember getting that and having the chance to look that over?
Yes, sir.
Now, in that indictment, you are charged with 1 count. And what's alleged here is on or about May 7th of 2023 in Willowick Lake County, Ohio, that you did knowingly cause serious physical harm to Deshaun M. White. That conduct constitutes the offense of felonious assault. It's a felony of the 2nd degree. And that's what you're charged with. That's not what you're pleading guilty to, but that's what you're charged with. Do you understand what you're charged with?
Yes, sir.
Any questions about it?
No.
Now, for purposes of the plea today, the state has agreed to reduce this charge and let you plead to what's called an attempted felonious assault. And what that is, it alleges that on or about May 7th, 2023 in Willowick Lake County, Ohio, that you engaged in conduct that, if successful, would have resulted or constituted the offense of felonious assault, which I just read to you. And what the significance of that is, it's a level less serious. Reduces it from a felony of the 2nd degree, which is more serious, to a felony of the 3rd degree. So this would be attempted felonious assault, a felony of the 3rd degree. And there's a big difference between that and the felonious assault of 2nd degree. Felony assault 2nd degree, you're looking at a maximum sentence of minimum indefinite term of 8 to 12 years. Here, the maximum sentence is 36 months. That's correct,
Yes.
right? Yeah.
Yes, Your Honor.
So there's a big difference, obviously, along with some other differences as well. So do you understand the difference between the two in regards to the penalty? And I'll go over more of the penalties in a moment, but in regards to what's alleged and what you're admitting to as well?
Yes, sir.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to a trial. Now that trial could be to me as a judge, where I listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence. Then those 12 jurors would make that ultimate decision. That ultimate decision reached by those 12 jurors would have to be unanimous, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when we speak about this burden of proof, since this is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden there is in our justice system. What it means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of that charge beyond any reasonable doubt before you could ever be found guilty at a trial of that charge. You understand that?
Yes, sir.
You understand by pleading guilty to the lesser charge here, you are giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt of the felonious assault charge?
Yes, sir.
Now, in order to try to do that, if we were going to have a trial here, if you weren't pleading, the state would bring witnesses into the courtroom to testify for the state, and they'd answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. So he'd be allowed to ask them anything he wanted to, within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, sir.
And you further could request this court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you, and answer your lawyer's questions if that person wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she would not be allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
To further understand that if we did go to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No questions.
Do you understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt, so it means you'll be admitting to the facts being alleged by the prosecutor in regards to this reduced charge. We're not going to argue you didn't do that or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, not today, but on a future day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to a felony of the third degree. This felony of the third degree is punishable by a possible term in prison of a minimum of 9 months a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So if I determined that a prison term was warranted, I would choose one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve for this case. Do you understand that?
Yes, sir.
Now, are you currently on probation or parole to any other courts or agencies?
No, sir.
Do you have any
I
other?
just completed Cuyahoga County probation.
Okay. So that's over with.
Yes.
Okay. And the only reason I ask that, if you're on, so you may have been on probation when this happened, but if it's over, then there's nothing that can happen. But if you're on probation with another court when you commit a new crime, there could be consequences with that court for committing a new crime when you're on probation. Nothing I could do about it or would do about it. It's not, you're not on probation to me. But there could have been there, but it sounds like that's not possible anymore since the probation's over.
Yeah, I mean, because this case happened before I caught this case.
But you were probably on
yes.
probation when this happened, though.
No.
No, you weren't. So you committed a new offense and got put on probation before this happened, or after this happened?
After this happened.
Okay.
Yes.
Okay.
Just further, I believe that he may have been on probation at the time of this offense.
Okay. Well,
Just for clarity's
let me
sake.
just make the record clear. If you're on probation when this offense occurred and you're still on probation, there could be consequences with that court.
Oh, I get what you're saying.
Nothing I
all.
could do about it or would do about it. But if you were on probation when this happened and you're still on probation to that court, they could file a probation violation against you. But if you weren't on probation at the time and or you're no longer on, then that can't happen. So whatever the facts are, they are, and I just want to make sure you understand that.
Yes.
Any questions about that?
No, sir.
Okay. Do you have any other charges pending against you right now?
No, sir.
Now, if a prison sentence is imposed in this case upon your release from prison, you have in here may be put on. It's mandatory, isn't it? F3 offensive violence.
I thought it was optional, mandatory if it was a high F3 or a sex offense,
Sorry?
but I might be wrong.
You thought it was what?
Mandatory if it was a sex offense or a higher tier felony of the third degree.
I thought F3 offensive violence are mandatory. Let's see. This man says each sentence to a prison term other than a term of life imprisonment for a felony of the first degree, felony of the second degree, a felony sex offense, and for a felony of the third degree that is an offense of violence and it's not a felony sex offense, shall include a requirement that the offender be subject to post-release control. That's mandatory.
I'm sorry, that was my error then. I apologize.
So in this case, if a prison term is imposed upon your release from prison, you would be placed in what's called post-release control. It's sometimes called parole. What that is, it's a period of supervision you will be on after you serve the prison sentence. Now, prison is not mandatory, but if you went to prison, this post-release control would be mandatory for at least 1 year. It could be up to 3 years, and that's not for me to decide. That's the parole authority to determine that. You understand that?
Yes, sir.
Any questions about that?
No, sir.
Now, if you found yourself on post-release control and ever violated any of the conditions, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each separate violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
All right. Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case up to $10,000. There's no mandatory fine, but it's up to the court. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
Yes, sir.
You could also be ordered to pay restitution to the victim for any economic loss any victim may have sustained as a result of the conduct involved. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible. Prison is not mandatory in this case with these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, sir.
You understand that just because you're eligible doesn't automatically mean you would be put on probation. It means I'll consider that if that's what you're requesting. I'm going to look at all the information that gets presented, then I'll make the decision that I think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you were put on community control sanctions, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. So what that means is that even if you get probation, doesn't automatically mean there's no jail time. Doesn't mean there is, but it's a possibility, and the court could order that as a condition of your probation that you serve time in the local jail. Do you understand that?
Yes, sir.
Any questions about that?
No.
Also, if you are on probation to the court or community control and you were violating any of the conditions, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years, if it wasn't initially 5 years. I could order more restrictive sanctions against you, including an order that you serve time in our county jail. Or I could terminate your probation at that point and send you to prison then. If I did it at that point, it could mean that same range I previously explained to you, 9, 12, 18, 24, 30, or 36 months. You understand that?
Yes, sir.
And if that happened, I could also order that be served consecutive to any other prison sentence you may be serving for some other case, or that you're being sentenced to at that time for some new case. You understand that?
Yes, sir.
Right. Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever any of the lawyers or anyone, quite frankly, have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that's the right thing that should be done. You understand that?
Yes, sir.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to go over this with your lawyer and have him review everything with you and answer your questions?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has he or has anyone made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily today?
Yes, sir.
All right then, Mr. Merritt, any questions from me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to speak with Mr. Watson before we go forward with your actual plea?
No, sir.
All right, then what's going to happen at this point is that the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to what she says, because now I have some questions for you about that, all right?
Yes, sir.
All right, Mr. Britsky.
Thank you, Your Honor. Facts would show that on May 7th of 2023 in Willowick, Lake County, Ohio, at the community center, there was an event where an argument was taking place that initially did not involve the defendant or the victim. Eventually, the defendant got involved in the argument and escalated it, and he approached the victim's sister in a manner that appeared as if he was going to fight her. Victim, in response to that, stepped between his sister and the defendant. After that, the co-defendant came to the side of the victim, blindsided him, and punched him in the side of the head. It knocked the victim out, and as the victim was falling to the ground, the defendant then punched him in the face. The victim fell, his head hit the concrete. He was hospitalized for numerous months, and he had numerous brain bleeds and fractures.
Co-defendant, is he still in Cuyahoga County?
No, the co-defendant is in our jail awaiting sentencing at this time.
Oh, actually, I'm looking at the pretrial, and I know that was a while ago. I don't think he had been served yet or anything. Okay. Mr. Merritt, were you able to hear what the prosecutor just had to say regarding what she believes the evidence in this case would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then, regarding count not count, but the lesser included offense of count one, the reduced charge of attempted felonious assault, a felony of the 3rd degree. What is your plea at this time?
Guilty.
All right, I have in my possession up here a document, 4-page document called a written plea of guilty and judgment entry, which sets forth everything we've just discussed. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, sir.
And just so you know, the only change I made in post-release control, it said, when I was talking about that, it said after prison release, I may have a minimum 1 year up to maximum 3 years of post-release control. I deleted the word may and said will, because remember I indicated that it would be mandatory,
Yes, it'd be mandatory
if you went
for
to
the-
prison. So now it reads, I will have a minimum 1 year, maximum 3 years of post-release control.
Yes, I
Understand it?
understand.
That's the only change that's been made to this since you saw it.
Okay.
So you went over it with your lawyer?
Yes.
Mr. Watson, is that correct? Did you review this with Mr. Merritt and read it over with him?
Yes, Your Honor. I did review the written plea of guilty. I read it to him. Mr. Merritt read along with me, indicated that he understood it. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
Mr. Merritt, is that correct?
Yes, sir.
So you understand what this document says?
Yes.
Do you have any questions for me about it?
No.
Now, your lawyer also indicated you signed it. Did you in fact sign it? It appears you did, but did you
Yes,
sign
sir.
it? And Mr. Gretzky, you did witness that as well?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum sentence that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of the lesser included offense of count one being attempted felonious assault, a felony of the 3rd degree in violation of 2903.11A1 and 2923.02. I will defer sentencing, order pre-sentence report and investigation, victim impact statement. Are you requesting any other evaluations?
I don't think any would be necessary, Your Honor.
Okay, that'll be that. I will continue bond, I believe $10,000, cash surety, 10%, no contact with the victim. So what all this means, Mr. Mayor, as far as bond goes, I'm continuing your bond, so there's nothing more you need to do at this point. But you do need to comply with the conditions of your bond, continue to do that. One of those conditions is that you don't use any drugs while you're on bond. You'll have to submit urine screens. If requested, those must be negative. A positive screen would result in your bond being revoked and a warrant being issued for your arrest. Do you understand that?
Yes, sir.
Now, the purpose of this report is so I can learn more about you before sentencing. I don't know anything about you. So I can make an informed decision at sentencing. The way the probation department gets the information they need to prepare the report is they're going to conduct an interview with you. It's important that you show up on time, when scheduled at probation for the purpose of that interview. Because if they cannot conduct the interview with you, then they cannot prepare a report. And without a report, the law doesn't even allow me to consider probation as an option. You understand that?
Yes, sir.
It's also important, obviously, that you be open and honest with them when you meet them. They're going to check and verify everything you tell them. If they learn you're misleading them in any way, they'll let me know that, and I would consider that as sentencing. You understand that?
Yes, sir.
All right. So you're going to leave here right now. You're going to go right over to the probation department. Do you know where that is or not?
No,
if not,
sir.
your lawyer will show you. It's in the 3rd floor of the sheriff's building there.
Oh, okay, so.
I'll walk him over,
Okay.
Your Honor.
You're going to just go up there, meet with them, fill out some initial paperwork, and get your date to come back for the interview. So make sure you do that when you leave here.
Okay.
All right? All right, Mr. Gretzky, anything else for the record at this point?
No, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
All right.